There he is. Let me promote him. Hi, Renee.
What's up, Facebook? So you want me to turn my video off now or later?
Sure, go ahead. Well, we can, or you guys can all be on. However you want to do it, Jamie. You're leading this show.
I don't want to take away from his energy here.
All right. I think Renee is now promoted.
Yeah,
Hello.
Hello.
Hi, Renee. We
Hey.
are on.
Good to see you, Jamie.
Good to see you, man.
All right, Jamie, take it away.
All right, folks. This is the Texas NORML August 2021 monthly meeting. We used to do them in person. As everybody knows, we're doing them on Zoom and Facebook now. Welcome. My name is Jamie Spencer. I am legal counsel for Texas NORML. NORML is the National Organization for the Reform of Marijuana Laws, and we are the Texas chapter. Tonight is lawyer night again. Tonight's focus is going to be on criminal justice reform. Maybe a little bit of talking about prosecutorial discretion thrown in there. And then also, you know, how do we measure progress? We just got through this legislative session, and in some ways it can be a major disappointment that we didn't get what we wanted out of this session, but also we got a lot further and we learned a whole lot of valuable lessons. And so we may talk about that a little bit tonight. I do have two guests with me tonight. One of them is Renee Vargas. The other one is Robert Guest. Renee is currently practicing in El Paso. And actually what I'm going to do, this is not a situation where our guest speakers are going to, this is going to be more like a conversation. So our guest speakers aren't going to take a 15 or 20 minute chunk at a time to just talk all of themselves. I'm going to be reading a document that was promulgated by the Travis County District Attorney's Office recently. I'll talk about that in just a minute. And since I don't have particular times, just one time that Renee and Robert are going to jump in, I'm going to do their resumes now. Robert got his law degree at Texas Tech in 2002. He is licensed to practice in all state courts in Texas and in Dallas federal courts. He's a former Kaufman County Bar President. He's members of Dallas County and Texas Criminal Defense Lawyers Association and a bunch of other associations, really, and has also been on the board of directors of the State Bar of Texas. Renee is somebody that I met in probably 2004, 2005. That's when he graduated law school and he started practicing as a criminal defense attorney immediately here in my neck of the woods in Austin, Texas, in Travis County, and also in the surrounding counties. We became pretty fast friends and hung out a lot. About 5 years ago, he moved out to El Paso, and he is currently working for the El Paso Public Defender's Office. He is the chief of the mental health and juvenile units there. He's tried more than 50 cases. So that's sort of my introduction without actually moving to our guests. And now let me get this share screen working, hopefully. Okay. So actually, before I do that, sorry. I do need to say that we always do ask a lawyer. So you can submit questions on Facebook. And if it's something that you hear us talking about that you think is interesting and it's a legal question or a legal issue, please throw that in there. We'll be happy to answer your questions. We will answer your questions. We're lawyers, so we might give you kind of a weasel answer, but we'll give you an answer. But also, if you have marijuana or drug law type questions, THC, concentrates, those sorts of things, please put those in the question and in the chat on Facebook as well. We will get to those. Those could be things like, if I get a ticket, instead of an arrest, does the marijuana charge show up on my record? Or, hey, UPS called me and they want me to come. They've never asked me to come down and look at this box that my friend sent me from Colorado. We get a wide variety of questions. We'll do the best we can with those. Also, at the end, our executive director, Jax Finkel, will talk a little bit about our upcoming events. All right, so back to the topic at hand, and really the sort of grand thing I'm talking about here tonight is criminal justice reform in general and the direction that's moving, how it's moving here in Travis, and then for Robert in the Dallas area and Renee in the El Paso area. I'm going to pass it off to them after, and asking them questions about how does this sort of thing work in your neck of the woods? How has that changed over time? Those sorts of things. See whether or not we can see if this, if we're getting this moving in the right direction. I think we are. So I'm going to start by talking about a front page story in the Austin American-Statesman that I read it today. I think it came out today. I'm going to read you the headline and then I'm going to read a little bit of it. We're going to talk about what's going on. Here is the headline. Top Travis County prosecutors accuse Austin police of refusing to investigate crimes. I'm going to repeat that because I think that's rather a shocking headline. And it's really not that clickbaity. It is not a misinterpretation of what's going on. Top Travis County prosecutors accuse Austin police of refusing to investigate crimes. So the article goes on to talk about how our district attorney and our county attorney are accusing Austin Police Department officers of refusing to investigate reported crime and inaccurately blaming their justice reform policies. Both of these prosecutors, the lead prosecutor for the felony division and the lead prosecutor for the misdemeanor division, those are elected officials, both of them have come in and really been very progressive about how they look at criminal justice. Both of them campaigned on, and this isn't a, Texas, I want to be very clear about this. Texas NORML doesn't endorse political candidates. That's not what I'm doing. I'm talking about the political climate that they ran in. Criminal justice reform and not spending so much and spending our funds more wisely and not tagging people with criminal records that really don't need to have criminal records. That was the platform they ran on, and they have been putting that into place. So going on with, and right, everybody knows the beginning of Law and Order, right? It's the police who investigate crime and the district attorneys who prosecute the offenders. Dum dum. Well, the district attorneys who prosecute the offenders are the ones that have the prosecutorial discretion to decide how cases will move through that system. It is an integral part of any prosecutorial system, is that they have to make certain decisions on how they're going to proceed on a particular case. The article goes on to say part of the latest issue centers on a new policy that the two prosecutors have put in place. Prosecutors now review cases prior to a defendant being formally booked into jail. As a result, dozens of possible felony and misdemeanor charges have been rejected before they are formally filed because prosecutors said the cases lacked probable cause, or they asked the arresting officer to gather more information. Police officers have considered that practice an affront to their work, while prosecutors say it weeds out cases early that lack sufficient evidence or are not aligned with priorities for prosecution. So, I want to call a spade here. Let's do it. Let's put it on the table. Part of what's going on here is a huge fight about police funding. The Austin Police Department, like many police departments, finds itself in a battle for funding. And like any bureaucracy or any government bureaucracy, probably either type this, every subsection of Austin Police Department thinks that they are basically the most important part of whatever that little subdivision is, right? And each of them want more money every year. And that's what we've been doing for decades, is upping police budgets. Well, when we go over the Travis County District Attorney new policies that are announced, you're going to see that one of the good things about it, at least in my view, is that it will require less funding police and use those monies for something that's useful instead of prosecuting crimes that people don't want prosecuted. That's an overall good thing. All right, so what's this document I keep talking about? Okay, there we go. All right. Does that pop up on the screen for everybody? Okay, you can see here that this is from the Office of the District Attorney's Office. It was put out a few months ago, and it ends with a flow chart that talks about how they are directing their in-court line prosecutors to deal with certain cases. In fact, it's not even just the in-court ones, it's the ones in intake before a case even has to come to court. I've highlighted some sections of it. And we're going to go over some of that stuff and talk about what we do with these sorts of policies moving forward. Okay, at the Travis County District Attorney's Office, we treat every case differently. Each offense is different. A victim is different. A defendant is different. There's so many differences. Because there is no one-size-fits-all, they say, we are asking our staff to incorporate the below principles into the work. And they talk about they're going to show a flow chart. The very first thing that they address is bail. Those who have committed heinous crimes and are a danger to the community should remain in custody pending trial. But we must work to ensure that it's not just the wealthy who are given an opportunity to be released when they are not a danger to the community. Remember, this comes from the prosecutor's office. While we cannot set bail ourselves, and what that means is they can make a recommendation on what a bail amount might be, and or they can make a recommendation on whether or not a personal recognizance bond should be granted. They are not the ones that set the bail amount. However, any practicing criminal defense attorney can tell you that for the most part, when prosecutors come in and say, you know, we think the bail should be X, a lot of times that's what happens. Or sometimes the police officers request a certain amount. So they start by talking about what the real purpose of bail is. You'll see the first highlighted section here. We will not consider a person who is an attendance risk, meaning they've missed court in the past, attempted to evade police, they're a flight risk of some sort. A lot of people, I think, instinctively think about bail as some sort of punishment. You're accused of this terrible offense, and the more terrible the offense, the higher the bail has to be because it needs to be punitive. And if you want a really short history of the American criminal justice system in the last 50 years, I just summed it up for you. And that is, hey, our system needs to be punitive. That's really what it's looking at. But that's not the purpose of bail. The purpose of bail is to try to assure that the person who is being charged and then being released knows when their court date is going to be, when they need to come back, and the likelihood that they're going to do that. So yes, if you've skipped a bunch of court dates in the past, I have no problem with the district attorney's office not pressing for your release. Now, your criminal defense lawyer might do that for you, okay? But remember, we're talking about just at a starting level. If you have a bad history of missing court, that's going to be taken into consideration. That's going to be a knock against you. The next one I think is really super interesting. For anyone charged with a state jail felony, there will be a presumption of release with no conditions if it is determined that the person poses no threat to community safety or risk of flight. So for the non-lawyers out there, state jail felonies, I think, started in Texas maybe in 1994, it's the mid-90s. At the time, we only had third degree, second degree, first degree, and then capital murder. State jail felonies were introduced again in the mid-90s, and they had a lower punishment range, and they were kind of the equivalent of fourth degree felonies. A lot of stuff from the third degree range, which was 2 to 10, came down to this 6 months to 2 years range. Probations were shorter and all those sorts of things. But the bottom line is most of those are drug cases. Any criminal defense attorney can tell you that if all they had was a steady diet of state jail felony cases, I bet 80% of them, maybe higher, would be drug cases of some sort. Not all of those are marijuana or THC, of course, but a lot of them would be drug cases. You see here that our district attorney's new policy is, instead of there was never a written declaration in the past that the presumption was for keeping the person in custody. But again, as a practicing criminal defense attorney, I can tell you that that's what it feels like when you're trying to get your client out, is that the system is working against you. The presumption is that you're going to have to do all of this work to prove that they should get out. Well, they're saying now, you know, if we don't see a reason, and again, I think this is common sense stuff, but it's extremely different from how things have been done in the past. Next level there, charged with a higher level felony, there will be a presumption of release with the least restrictive condition necessary to ensure that the person is not a risk of either flight or a safety risk to the community. Next year will be 25 years of doing this for me. And this is sort of turning the system on its head, even in Travis County, which I think has had one of the most progressive personal recognizance, PR bond type of systems in place, and it's gotten better over time. Again, not overburdening somebody. It's not uncommon in the past, when someone got arrested, that not only might they have to have an ankle monitor or maybe an alcohol monitoring device, or be told that they have to go to certain classes, and those classes can pile up and they cost money. It's like putting the person on pretrial probation before they've even been convicted of this. So the district attorney is saying that we're going to try to whittle those conditions down to the least restrictive, but still stay within our duty of protecting the public. Let me do this if I can. Let me throw it out there now. I'm going to start with you, Robert, if you don't mind. What have you seen in your neck of the woods in terms of what sorts of folks are used to get PR bonds in the past, pretty much rubber stamp? And I know that you practice in different counties. Is it sort of different in different places? Have you seen it getting better? What's sort of the situation for where you're practicing? And I am aware that you primarily practice in one of the counties that is considered pretty tough.
Okay. Thanks for kicking over to me. Yeah, bail's a very local practice. And so my main office is in Kaufman County. That's where I prosecuted. And I tell people, because it's the county that borders Dallas, and I tell them when you cross the county line, you go back in time 30 years, because we still have pretty oppressive bail practices. And now on top of that, they've added into it like pretrial services, which is, as you called it, pretrial probation. It's true. You're reporting, taking drug tests. They want psych evals. They want all this stuff. And we have no discovery. We don't have any kind of evidentiary hearing. You're just forced to do these things. And so as long as I've been doing it, Dallas County's had the most favorable bail policies, from everything from like how much they charge to who gets PR bonds to how fast it happens. In the rural counties, we're all waiting on those 90-day, writs. And that's when like someone hasn't been indicted, right? You can ask them to set reasonable bail. Otherwise, people don't really want to do it. A lot of it has to do is because all politics are local. Your judges are elected. And in conservative counties, especially when it's just like a one-party county, no one's going to lose voters or lose their job for being too mean to defendants or setting their bail too low. And so it's a risk-free move most of the time in rural counties to just slaughter people on bail. And so most of the reform in those areas are driven by economics. And so the sheriff's going to say, hey, I can't farm out these beds to the feds, because they can make money. I can't rent out our jail space if you guys have it full of state jail dope cases. And so most of it's cost-based, like the sheriff's healthcare budget goes up. So they go, man, maybe we should really move some of these people. Like if you have somebody, and you've probably seen this, if you have a client who's got dialysis or cancer treatment, all of a sudden, in a small county, that can destroy their healthcare budget. So reform happens for different reasons than just, man, we really shouldn't hurt people so much who haven't been convicted. It's not any kind of libertarian impulse to stop government violence. It's more of, this is expensive and we can't rent out our Holiday Inn jail to the feds, if it's full of these ticky-tack cases.
What is the state of cite and release, and the places that did implement it, when did they implement it? I'm going to brag a little bit. Austin Police Department was, this wasn't my doing, but I'm bragging anyway. APD was the first law enforcement agency anywhere to come up with a cite and release after that was passed in 2007, I believe. What are they doing for that? Is everyone getting arrested in some of your counties, or is it half and half?
Dallas does cite and release. I think in Kaufman and Rockwall, I've seen one, and I was shocked. I fell out of my chair when someone goes, yeah, they just gave me a ticket for this marijuana case. And I was like, really? And there was some weird circumstance, like it was a younger person, they let him go, but nobody wants to change. They like the arrest. They like having the inventory search of the car. They like all the things they get with it. And so, sometimes a cop just won't make an arrest. And I think people who consent to searches are kind of counting on the cool cop who'll let him go. And you can play those odds, but if you're wrong, you're really wrong. But when they do decide they make an arrest, like cite and release, at least in the rural counties I practice in, is extremely rare.
Okay, let me jump over to Renee. Renee, what is sort of the bail situation in El Paso in terms of personal bonds? And you've been there, only 5 years, but I know you've met other people that have been there longer, and we criminal defense lawyers like to complain about how bad things used to be. What's sort of the story in your neck of the woods?
Well, it's gotten better. And after practicing in Travis County for 11 plus years and moving here, I was sort of spoiled. And I had to tell myself, don't be the, well, back in Austin guy over and over again, right? Although, so I was pretty angry, pushed back a lot about some of the stuff they did. El Paso's a weird neck of the woods in a lot of different ways. A lot of it is because there's a weird sort of cultural conservatism that runs a street that runs through town that a lot of people don't know about, even though, it's a blue county. You don't stand a chance in hell of winning a local election if you're a Republican. However, culturally, because it's, 75% Hispanic, there's still, that conservatism that runs through. And judges and prosecutors are even more conservative than your, a community member. But there's not a lot of high voter turnout, not a lot of knowledge, so they do what they want. However, over the past 5 years, it has gotten a lot better. Pretrial services, the PR bond here has gotten more robust and more open. It's not like Travis County yet, where you just have pretrial services sort of rubber stamping a bunch of personal bonds and then or approving personal bonds and judges rubber stamping them. You still have a bond hearing every single time for them. But they run an algorithm now. I don't know if they're doing that in other counties, where pretrial services will prepare a report, a pre-release report on a defendant on a scale of 1 through 4, and 4 being the highest risk of them not returning or recommitting another crime. And it's interesting when you look at those numbers too, even the high risk, statistically, that still says like 80% of those people that are high risk still don't reoffend and come back to court, etc. But when it's relative like that, then you're going to get a lot of judges like, no, 4, that's it, you're not getting out on bail. What is interesting though, having recently over the past year and a half or so being in charge of the mental health unit and dealing with those issues, is there's actually a provision in the Texas Code of Criminal Procedure called, or under 1622, which means if you've been diagnosed with a mental health illness, and the sheriff realizes this and they issue this report that says as much, and you've been diagnosed with something, then if it's not an enumerated crime like an assault, basically a violent crime, then you're entitled to release if you have a mental health illness and you're not incompetent and you're not violent, then you get released. But again, with all these conditions, like Robert was saying, that you're basically on probation before. And with mental health clients right now, it's a real struggle and a fight that I have to deal with this person needs to get mental health treatment. And I agree with you, Jamie, that, the only reason people should get their bonds revoked, get thrown back in jail is if they, basically if they commit another crime or they don't come back to court. But what's happening with these mental health treatments is like, there's conditions like take your medication, go do psychiatric counseling, and they're getting bonds revoked, meaning people are getting thrown back in jail for not doing this. And I'm trying to, it's a battle to educate judges, prosecutors, pretrial services that, these conditions should be sort of ambitious, meaning if someone isn't doing them, like if someone isn't going to a doctor's appointment, are we going to take away their freedom? Or maybe we'll just have a hearing and encourage them. But overall, to answer your question, yeah, in the 5 years I've been here, it has gotten a lot better. It's not where I'd like to see it, in Austin. And I know lawyers in Austin and you are still going to complain because it can always get better.
Right. Well, that's good. I'm glad to hear that things are moving in the right direction. I'm going to attempt to share screen again here and go back to some more exciting stuff. That's the one to share. Okay, so Discovery Brady. Again, this is from our district attorney. We should be as open and forthright with Discovery and Brady as possible. Let me just stop right here and say something for the non-lawyers, because that last sentence that I just said should be obvious, and it should be the policy of every prosecutor's office. It should have been the prosecutor's policy since the beginning of time. And yet it's not even close to what the law is in terms of what it says that they have to turn over to us. At least, I mean, in theory, the Brady part is, but we'll get to that too in just a minute. So the law says only that the prosecutor has to give you, you and your defense lawyer, documents, evidence, videotape, whatever it is, witness statements, anything that is helpful to your client. But of course, they're the gatekeeper. They're the ones that determine what is helpful to your client. And frankly, when we're talking about police reports, this probably won't surprise anybody, but police reports about how a police officer arrested my client are rarely full of really great things that help my client prove that they didn't commit the case, right? It's written from the exact opposite. So police reports, yes, criminal defense lawyers have to, in many places, explain to their clients, we not only don't have a right to get the police report, but I can tell you we're not going to get it. For example, Williamson County, which is just north of me, had one of the harshest reputations in Texas of all 254 counties. And in the 90s, I might be sitting in a prosecutor's office, literally across the desk from them. They would open a file and say, okay, Jamie, what do you want to know? And I would say, well, what happened? And occasionally they would tell you something as little as, well, the prosecutor stopped him for speeding and they found the cocaine or the marijuana, the THC or whatever it was. Literally, they're not obligated to tell me anything. So let's go back to what this says, right? Open with discovery in general. Now, that in theory, they're talking about all discovery here. If we are in possession of offense reports or other materials pre-indictment, and there is not a legitimate law enforcement reason not to give it to defense, we should make it available regardless of whether there has been a defense request. This is as probably good a policy as I could remotely imagine about discovery in any prosecutor's office. They go on to say legitimate reasons could be maybe there's stuff in one offense report that refers to some other crimes going on or those sorts of things. You could see later down on, it says we should always err on the side of caution and turn it over. If you have to ask if it's Brady, turn it over. We should always notify the defense when we specifically find Brady. Now that is a constitutional requirement, especially if it is a voluminous case with thousands of pages of documents such as CPS records. We get hospital records all the time. And all this does is, again, common sense, but they're making the promise that when they find that stuff, if we didn't find it, they're going to go out of their way and turn that over to us. They're going to point that out. All of these things are reasonable. I doubt this is what it's like for you two, but since we did it before, why don't I start with Robert and ask him, first off, do you have any place that just refuses to give you the police reports entirely still? Or
no, but Ellis County was one of the last closed file counties. That's this county south of Dallas. And you would go there and they would read the police report to you or as much as they wanted to. And the deal was, if you had a discovery hearing, you had no plea offer. You had to go to trial. And so it was just so awful. And they used that because that could get your guy to plea. And it was a hustle for them. It was total leverage going, we're not going to tell you what it's about. And they were real curt about it. They'd be like, well, ask your client what happened, defense lawyer.
Oh, like, yeah. Oh, yeah. He knows what happens, they say.
He knows. He was there. He was there too. And
when did that change?
When Michael Morton passed, they went down swinging going, we're not giving you guys anything. And they weren't going to change until that happened. And so Dallas has never been a real problem. The problem we have, and this is what I see more often than the prosecutors like hiding the secret report for me in rural counties, is the police don't turn it over, or they don't get stuff turned over till right before trial. And so you'll have a case that's 2 or 3 years old, and then all of a sudden you got trial next week and they go, whoa, we found this video. Okay, we had a trial. It was in Rockwall, and they did this twice to us. Like the week before trial, they dumped documents on us going, well, we just found this, oops, this was in a drawer somewhere. And once we got a continuance, the second time we didn't. And it was like a bunch of DNA, testing back notes. And the judge was like, well, what are you going to do with this? And we go, well, I'm not a DNA expert. I just got this. I have no idea. And so he denies our continuance. And so it's late disclosure could be as bad as no disclosure, because the Court of Appeals aren't going to take it up as like, oh, late disclosure is so bad. Right. And so the case law on it kind of sucks, but that's also as harmful as hiding stuff, because then they get to say they gave it to you, but you have no way to help your client with it, and they've had it the whole time.
Right. Renee, what's it like for you?
The DA's office, the prior administration, we have a new DA, and they're a little bit better about that. But I had flashbacks right now practicing Williamson County pre-Morton and before Janet Duty took over. I remember when she won that election, I walked into district court there, and they're like, "It hasn't been indicted yet, but here's a file. Go ahead and look at it." And I'm like, "Where am I?" But in El Paso, our office put up a big fight because we were subpoenaing a bunch of stuff, a bunch of records, and the district attorney was filing a bunch of motions to quash. For you non-attorneys, it means to ignore the subpoena, right? And they would argue that under 3914, which is the discovery statute here, that they would argue that we had to prove why this report that we wanted, or these whatever evidence that we just want to investigate, why it was going to be relevant. And our answer was like, well, we don't know yet until we see it, right? Well, I can't tell you ahead of time without seeing it. I can't predict the future. And thankfully, recently, the Court of Criminal Appeals weirdly came out with a really good case, Watkins, that defined material under that discovery statute. And I think the new administration here sort of had an oh shit moment. And when we bring that to light, the Watkins case, that anything that we can say is material, not admissible in court, not relevant, they have to turn over. Some of the judges are still a little bit behind. But in El Paso, we actually have a district attorney portal, which is really cool in that everything's online. So there's no more hard copies. I don't know if Travis County's moved to that.
We have essentially, yes.
Okay.
We use a tech share. I don't know if either y'all use that. A lot of counties are using that, but yes, electronic discovery is fantastic. And it seems to me like making it easy when it became easier for the DA's offices to give electronic discovery, they may have loosened up a little bit on it. But yeah, the electronic discovery is fantastic.
Yeah, and the juvenile system's the same. Weirdly, again, El Paso was like way ahead of the curve as far as electronic discovery and having this district attorney portal, and then an app that the juvenile department here, they actually have their own tech department, and they created this app that everything is uploaded onto, including juvenile probation notes, etc. But I want to get back, Jamie, before I forget, to the first slide that you showed about
Yes.
About district attorneys now. Guards are complaining about cops not investigating enough. I tell people this all the time, and I used to tell clients, like, when you call the cops, they don't solve your problems. They just show up and they write a report and take someone to jail. And I still tell people all the time, like, they don't investigate anything, really. Like, normally the victim in a crime solves their own case, right? 87% of murders are committed by people who know each other, number one. And if you don't get murdered, normally who assaulted you, and you solve it for the police right there. There's not a lot of sleuthing going on, and this is largely because of the war on drugs. The war on drugs, because everybody here that's tuning in, probably knows about civil asset forfeiture, which is just like the self-feeding beast. So why would you spend time and resources investigating who stole Robert's bike, right, when you can get these jump out boys to go, bust some crack dealer and take all their shit, and then you have a bunch of money coming to the police department? So this idea of police work and it being, CSI investigating, that's a myth.
I think that's a good point. All right, let me bring this back up again. All right. Now, I don't think the two of you are going to believe this one. I was shocked by it. Readiness. If efforts, this is from the prosecutor's perspective, if efforts to contact necessary witnesses have failed, or the witness refuses to cooperate and charges cannot be proven without the witness, defense counsel must be notified after 30 days post-indictment. If after 6 months and reasonable efforts to contact necessary witnesses have failed and or efforts to gain cooperation have failed, the case should be dismissed as witness not available. Then they talk about because of the pandemic, they measure 6 months differently. But now, again, starting with the audience of mostly non-lawyers, that probably sounds like something that wouldn't even need to be said out loud, that if a prosecutor doesn't have witnesses for a case, that should mean that the case goes away. But it doesn't mean that at all, because number one, they don't have to tell us about the availability of witnesses. That's not a legal requirement at all. And I mean, we play witness chicken. Defense lawyers play witness chicken all the time. I mean, that's what we call it. Sometimes the only way you can win a case is by hoping that some particular witnesses don't show up. And I've had 2 trials, jury trials, where that happened in the middle of the case. It's actually pretty rare for it to go that far, because typically they'll figure out just a few hours before the trial is going to start or something like that. But obviously it can happen in trial too. But it's an enormous waste of resources. It means the prosecutor has their case on their docket for an extra year and a half on all these different jury dockets. It means I have to have a little mini heart attack the weekend before the case is set every time, thinking, man, I'm pretty sure this thing isn't going to go to trial, but I can't do nothing. I'm going to have to prepare it for the umpteenth time. All of those sorts of things. It's just an incredible waste of resources. Here we have a district attorney's office saying that they're going to go out of our way not to play those games, move the system along a little faster, and just for the folks out there, again, this doesn't, there is a statute of limitations. It was stopped while your client was having to go to court. So they're going to have 2 years on a misdemeanor and 3 years on a felony after this to still potentially find those witnesses. But for now, the case is dismissed. And for all practical purposes, most of the time I would expect it to remain dismissed. But this formal policy announced that they're not going to be playing those games with us. I think every criminal defense attorney has some sort of story where they talk to the prosecutor, they have a trial next Monday morning, they talk to the prosecutor almost every day that week. Sometimes the prosecutor will lower the offer 10 years, 8 years, 6 years, 2 years. Your client still says no on Friday. And then you show up Monday morning and they hand you a dismissal because they know they can't make their case, but they were still trying to, get your client just to sign up for his prison sentence. And so in theory, those sorts of shenanigans are, I would say, forbidden by this, not only forbidden by it, but really, again, reversing it and going it in the correct decision. I do not expect such sorts of news from Robert and Renee, but I'm going to switch around this time. Let me start with Renee. Renee, I assume that witness chicken in El Paso works exactly the way it did here when you started.
Oh man, it is awful here as far as that goes. Especially, I don't know if it's going to continue because we haven't had trials really with the new administration. But I had maybe one of the biggest nightmare trials of my career because through a witness chicken case where the state filed the writ of attachment, which for those non-lawyers that don't know what that is, if basically it gives the district attorney power to go arrest complaining witness, to go arrest victims and bring them to court to testify even if they don't want to. So one of the first cases I tried here, they wanted my guy to go to prison. I knew that his ex-girlfriend didn't want to prosecute, that it was a misunderstanding, etc. And he was habitual, means he was facing 25 to life if convicted. So it was this nightmare scenario. And after we pick a jury, complainant doesn't show up. The DA asked for a writ of attachment, so a warrant for the complainant. They issue that. They still can't find her. In the middle of trial, the judge grants a 3-week continuance. So I have a jury out for 3 weeks while the police department and the sheriff's department are out there looking for this woman. At one point they find her, and even the sheriffs are like, are we supposed to knock down the door? Like, we don't want to victimize this woman again. And then it was a nightmare. Eventually it was a not guilty. It was one of the biggest victories of my career, and it felt like I was fighting the judge on it. But I think it's important to note that the writ of attachment statute got changed about, probably 3 or 4 sessions ago, making it harder for a district attorney's office to do that. Because in Houston, this poor woman who's living on the streets in Houston, she was the victim of a serial rapist that was raping homeless women. She turned her life around, was living like outside of Dallas somewhere. married, stable. They found her, brought her to court. They finally found this, this defendant. They brought her to court on a subpoena. She flipped out because it sort of brought all this stuff to light again, had a mental breakdown. They found her wandering the streets outside of downtown Houston. And so they issued a writ of attachment to bring her back and and they took her into custody. The trial ended in a mistrial, but she got lost in jail where her mom kept calling the DA's office, kept calling everybody she could. And like, my daughter's in jail. They kept her in jail for 30 days. No one knew about it. She was assaulted because she was a witness. She was assaulted by the inmates in the Harris County Jail. She was assaulted by a detention officer and then finally released. So thankfully, State Senator Whitmire got wind of this and made it a little bit harder for them to do this. And actually, now they have an attorney. Now, whenever there's a complaining witness that gets attached, that gets a warrant, they have an attorney so that they don't fall through the cracks again. And it's really a nightmare scenario. And a lot of people don't even know that this stuff's going on. I didn't know that it was going on. Yeah,
that's crazy. So are you saying that an attorney would get appointed in El Paso for this person that they potentially find somewhere else, and it would be similar to an extradition hearing?
Yeah, sort of, because they're not
for
there,
a witness.
Right? Normally the witness isn't there, so
right.
Get appointed. In fact, our office, when I was assigned to a particular court, whenever that would happen, I was like the default. We're the default lawyer. So like, hey, the DA filed a writ of attachment. Get up here because we're going to appoint you on this complaining witness.
Okay. Robert, witness chicken and
all the time.
Your thoughts?
Yep. I hate it, but I mean, I tell people the state has so much leverage, and one of the ways they leverage plea negotiations is by wasting your client's time. Like our local courts have these rules where you show up every month. And so you got a guy and the state has a case and we think they can't make it. But part of them knows, well, if we just make this guy show up every month for 2 years and he has to miss work and sit down at the courthouse for 2 hours, it makes it more likely they take a plea. I mean, I used to be a public defender and my clients would say, I'll take this, but I just want to make sure I don't have to come back to court again, right? You're like, well, yeah, but that's not the reason you should do it. But they just thought that was the worst cost. And the state knows that. And COVID, when we quit having dockets all the time, I mean, that was a big win for us because the state couldn't just waste people's time, make them miss work, which is a huge cost imposed on people. And it's like everything else in the criminal justice system is regressive and just brutality against working class people and poorer people. But that's kind of the point. I mean, for everything from cash bail and wealth-based detention, it's, people who have the least amount of resources are brutalized the most by these policies. And, like some people couldn't even get a ride when I was a public defender. Like, how do I get to court? I'm like, oh, I don't know. Like, I can't help. I'm sorry. And these are things that only affect people who have the least resources. And so with witness chicken, it's the people who can least afford to hold out who go, well, I'll take the plea because I can't afford to wait. I can't keep coming to court every 3 to 4 weeks forever. And
happens routinely. For people that don't know, this is a common experience that criminal defense lawyers, when we go to lunch, we complain about amongst ourselves. So I'm going to wrap that up by saying it sounds like both of y'all would be in favor of some sort of prosecutor policy where they actually told you whether or not what the state of their being able to contact the witness is, right?
I would love it. We should make it an ethical Brady disclosure going, hey, the witness isn't there. But for some reason, it's not considered that. It's like, well, that's just an availability issue. And so.
Right. I mean, it's all in from, go ahead.
I agree. And here, what you'll get from the DAs is like, oh, they're on board. And then, luckily at our office, we have investigators who know full well they can't find this person, or they're like, I'm not going to court. And yet you still have the DA saying they're on board, just trying to force your hand, because there's this mystery out there. And just like Robert said, I think it should be, and I have argued in the past that it should be a Brady violation. Like, what can be more exculpatory than not having your goddamn witness there?
I recently was sent to my first jury docket in a while in a felony courtroom. It was out of county because Travis County isn't doing that at this point. Well, they are and they aren't. At any rate, COVID aside, their there's another experience that defense lawyers have, right? And it's listening to the prosecutor stand up and announce ready on 35 different cases for next Monday, when you know for a fact that's not close to the truth. And everyone pretends like it's okay for them to make that representation, right? And then our clients suffer because of it. All right, so guys, typically when we do a Q&A portion of it, we try to start that part at 8:45. So I'm not going to get through that document entirely. As you can see, as Travis County goes, maybe eventually, the bigger cities will start implementing some of these measures as well. I want to get the word out there to people that there are prosecutors' offices now that are seriously considering what their role is and how they ought to go about it. We didn't even get to the flow chart. That's fine. I'm going to throw some questions out as well. I'll start with some of these here that are in the Q&A. Now, I'm going to insist on this. I had a specific question in mind when I told you might get a Weasley answer from us, because I'm going to give you a Weasley answer to question number 1. Is Delta 8 illegal in Texas? And the most Weasley answer I can think of giving you is maybe.
Someone's gonna litigate that.
Right.
I don't want to be it.
That's right. So, before the Brady case, remember we were talking about Brady and how they have to turn stuff over to us, right? That wasn't the law before Brady versus Maryland, right? Somebody had to go and make that law and say, hey, look, they should have turned more stuff over to me. In this specific case, they should have turned the stuff over that tended to show that I was not guilty of this offense, right? So, to some extent, we didn't know that was the law, and until the Supreme Court said it was the law. Well, there are, I guess my first stab at answering this is to say that there are some conflicting statutes out there about analog substances, and it also is sort of two questions in one. Even if I could tell you that I had the best legal theory in the world for why it's not illegal and therefore okay for you to possess it, that in no means you won't get arrested and prosecuted for it. So I personally am telling people that this is at best an open question. Let's not forget that, there was that Pennsylvania prosecutor that made herself famous by going after Tommy Chong, when he was in California, just because he wanted to make a name for himself. And something like that could happen in one of the 254 counties in Texas. I'm sure there's prosecutors that would love to bust some, Delta 8 farm or some operation where Delta 8 was being extracted, even though there wasn't some other kind of THC in there. So it's an absolutely relevant question. I think maybe Robert wants to jump in.
Well, here's why I'm pessimistic for 2 reasons. One is, who's going to decide this issue? Which group of completely non-biased jurists who just all happen to be former prosecutors? It's the Court of Criminal Appeals. And that's where defense lawyers' hopes go to die, because they've got an agenda, which isn't, to help out people who like Delta 8. But if you've read, and this is the other reason I'm pessimistic, it's if you've read the case that made cannabis sativa L. Texas has a very specific marijuana definition, and it's cannabis sativa L, and it's marijuana with an H, which is some kind of quirky things we do. But there's an old case. This guy goes, I didn't have cannabis sativa. I had cannabis indica, prosecutor. And at that time, the highest court said, well, this definition includes all the cannabis family. They just added it by judicial fiat. And so I'm thinking, man, I'm not optimistic. I've seen everyone on forums has their great reasons of why it won't happen. But if the Court of Criminal Appeals is the last say in it, I'm just going, I don't know, man. It's better off if they just legalize something, or because if not, someone's going to get hurt, because all these, THC kind of things are they're state jail felonies at least, right? There's no misdemeanor version of Delta anything if it's going to be illegal. And so someone's going to get a real felony, go to jail sentence. And I hate to see that. These aren't people we need to be brutalizing with prison sentences and felony convictions, but that's going to be the person who's going to have to take it up and go, okay, this was wrong. And it'll probably be from some rural county. It's not going to be Travis County with,
Well, we were seeing that with CBD before, right? So like in Corpus Christi, as an example, little old lady got some CBD oil before the hemp program passed here in Texas and was told it was totally legal. Well, the cop decided it wasn't, and she got charged with a felony. I think ultimately it was pled down, but Delta 8 could be something like that. You know, according to the Department of State Health Services, DSHS, they've put out a memo saying that in some meeting that we can find no record of, no announcement of, no minutes of, that they've put together a memo that they deem Delta 8 to be illegal. So you can go to texasnormal.org, go to our blog, and you can find it there. But in practice, I'm not hearing of people getting rated for Delta 8, right? So something being illegal versus, you know, enforced is another thing, but it just, you're not going to beat that walk, or that you might beat the rap, you won't beat the walk. Is that the
Right.
saying?
You can beat
Yeah.
the rap, you can't beat the ride.
There you go.
No, and that's a consideration people need to take in. And then why would they even plead it down? Well, it's those factors we were talking about before. Do you want to come back 30 times for jury trial, or do you just want to take this little misdemeanor back time and get the hell out of Dodge, right? That's where those sorts of pressures really start piling up. Renee, I didn't know if you had something you wanted to jump in with.
Yeah, I mean, thankfully, you know, practice primarily in Travis County, and you know, if you push back hard enough as a defense attorney and fight them, they'll dump them. You know, 99% of the time, these marijuana cases. I've actually only ever had to try one weed case my entire career, and that was in Williamson County, right? A misdemeanor weed case, because everywhere else, you know, everywhere else they either dump them or your client just wants to get it over with and you know, just take a deal so they don't have to come back to court anymore, etc. In El Paso, you can imagine the drug cases that we get here. A lot of the state drug cases, a lot of the juvenile cases that I get would be federal in a lot of other places, but you know, the feds don't really mess around with anything less than like 500 pounds here. Our office right now has a 700 pounds of meth case that we have, because the feds are like, that's small time here.
Yeah.
But just like you were saying, like you can beat the charge, but not the ride. Cops are always going to hate, but then it depends on, you know, your prosecutorial discretion. Is the juice worth the squeeze? Usually it's not.
And to the people watching, just as a disclaimer, Delta 8 is a form of THC. If you consume it, you will test positive in a UA for THC. It can also have an intoxicating effect, so be careful about that if you're out driving or out and about. So just wanted to put that out there in case people were not aware of that. And actually, I have a specific question for Renee. So recently, El Paso was talking about the city council allowing an expenditure for $72,000 to be allotted for THC testing. And I think that they were supposed to meet on Tuesday, perhaps, or maybe it was today. I was wondering if you knew anything about that situation or what might have come of that.
I know a little bit, not specifically a lot about that, but it's basically because the new district attorney here is fighting it out with the police department. So basically, the DA is going to dismiss these cases, these marijuana cases, and going to go forward with even trying to have it tested at the DPS labs, etc. But the police department is upset about this. And they want their own testing, I suppose, so they can give that evidence to the DA and force their hand. There's a screening process here called DINS in El Paso, which the El Paso Police Department has started to circumvent and starting to get warrants without getting them screened by the DA's office, going to friendly judges, stuff like that. But just to give you an idea of why, we have a chief of police here who is an African-American gentleman, but you know, last year he was quoted as calling BLM a terrorist organization. So he's really, you know, they don't like it. They don't like the fact that it's quasi legal now, right? That the DAs are dumping these cases. And so that's what they're doing. There was a question in the Q&A I saw earlier about that. And that's why, you know, the police department is lobbying city council to pay for that, because the district attorney isn't going forward with those tests anymore.
So I'm just wondering, does El Paso have a backlog of rape kits like Austin does, that they could better spend that $72,000 on perhaps testing?
Oh, yeah. Yeah.
Okay. I figured.
And on investigating, like I said earlier, right? Like investigating property crimes, investigating serious assaultive offenses rather than these, you know, these weed charges.
Yeah. So also, if you want, there's another question here about gun rights, specifically. Dave is asking, are teacup patients in peril of their Second Amendment rights? Can a teacup patient get a concealed handgun license or purchase a gun legally?
I'm not an expert on that by any means. Those are great questions. I think that generically speaking, depending on how they set it up, you could somehow pass constitutional muster and still say, somehow your Second Amendment rights are restricted because of this. I mean, I don't think that there is a real legal basis or justification for denying felons their Second Amendment rights. The courts have said I'm wrong about that for a long time. But for example, you absolutely would not be able to say, hey, if somebody's a felon, they can never have a jury trial again. I mean, everybody has a right to a jury trial, but once you're a convicted felon, right? What is another right like that? Well, they have in the past shown, right? The Supreme Court has effectively put its thumbs up signal on saying, yes, there are ways of restricting Second Amendment rights. Now, specifically right now in Texas, I don't know of anything that would, but that doesn't mean it's not there. If either of you two have a more specific answer, that's great. If not, I don't know that. I can try to figure that out and come up with an answer by the next lawyer night, which is probably about 4 or 6 months from now. But
look at the federal statute, because there's something about if you're a person who's like addicted or uses controlled substances, that's the one I remember, and I can't cite it off the top of my head, but it's a federal prohibition.
The 11E.
And it's like if you're a user of a controlled substance, and since marijuana is still Schedule 1, which is beyond stupid, I have to imagine that's going to be a prohibition on you transferring or any kind of federal, interstate with a gun. And so I think that's more of a problem. But someone look that up for next time or Google it.
All right. If a cop comes into my house for something and sees my 30-to-1 CBD plant in full flower, can I get into real trouble? I'm not trying to give this question short shrift. We are a little bit late on time, and I'm going to just say that you can kind of refer to our first question, which was about Delta 8. I mean, yes, I think you could get at least in the front portion of trouble, which is that you get arrested, you have to hire an attorney, you have to go to court for forever. I would, I think from there, it's going to depend on the jurisdiction you're in, whether or not you would have to try to go to full-blown jury trial to beat that, or whether you could convince a prosecutor. In Travis County, I'm fortunate because that wouldn't even become a client for me in the first place. If a police officer made that arrest, we didn't go through it entirely, but there's a pretrial review process, which would really kick that out sometimes before booking. Even if there is a custodial arrest, meaning that person would not even need an expunction, but that is rare. And until we get really clear guidance from really direct worded statutes or from the Texas Court of Criminal Appeals, as Robert was saying earlier, that says that any of this stuff, I mean, I think you can get in trouble for any of it. People are still getting in trouble for it, less than they used to, but you absolutely have to be.
Listen, if a cop wants to get you for something, they're going to find a way to get you for something. And
it looks like a pot plant. They have probable cause.
And I just want to jump in. I see a couple people on the Zoom have their hands raised, and I just want to guide them to the Q&A box to drop their questions. We're going to do about 10, 15 more minutes. But also, I wanted to jump real quick. Renee, I see you're chatting with Dre here about can a marijuana charge be seen on your background, and talking about the difference between something being sealed or expunged. I think we should talk about that because expunction was actually a priority in the House by both the Speaker and Representative Nicole Collier authored a bill about it, about all kinds of expunction. So would you mind maybe just touching on that real quick for everyone?
Sure. Right. So In almost all cases, a marijuana case is going to show up on your background, even if it was dismissed. Really briefly, I'm going to start with the exception and then put everything else in it. Unless you're in a place like Travis County, where not only you quote unquote only get a ticket through cite and release, but when you show up at that justice of the peace, what we've arranged in Travis County is that, and Renee, I think this is since you left, they actually get told right then and there, hey, if you want, you can go take this 4-hour class. You don't have to do any community service. You take a 4-hour don't smoke dope class. You bring it back to us. You bring us that certificate back in a couple of months. We will not even file the case. And what that means is, the case just never started. It would be the equivalent of if a police officer physically handed you a ticket, right? But what happens? He's got a copy of that, right? And then that gets processed. And at a certain point, that speeding ticket is going to show up on your driving record, even if it was dismissed. Well, we found a way to short circuit that in Travis County for the vast majority of our misdemeanor marijuana cases, which is fantastic. It's how it ought to be. Other than that, if you were booked, if you were fingerprinted, if you were photographed, and actually, even if you went through the process I talked about, you might want, you could just check with a local attorney, and I can look it up really quickly and verify, no, there aren't any records at JP5 of that for you. But generally speaking, yes, a dismissal does not make a case go away. And many employers believe that if you were, they don't care if you were convicted. They just want to know what you were charged with. It's the same thing to them. Now, a lot of them may not care about marijuana, but yes, they'll be able to see it. I think that covers it, but I don't know if you guys had anything to add to that.
Well, once you've already got the charge, what do you have to do to make it where it can't be seen on your background check?
So that's fully you don't have that choice. Only if you live in a system like Travis, where you're told we won't even file the case to start off with. Mm-hmm. It would be like if the best analogy I can make is to complete my speeding ticket analogy. Assume that right after getting the speeding ticket, you and the police officer both drove to municipal court. You're both there, and the clerk says, hey, Jamie, if you take defensive driving, see this other half of the speeding ticket that the police officer is giving me? If you come back tomorrow with your defensive driving certificate, we'll throw the police officer's record that you ever committed this speeding in the trash. That's not how that works. But what I'm saying is, in the marijuana case, that really is kind of how it works. In Travis County, that's extremely specific. I think that Houston has something.
They have a first chance program and they have a diversion program.
They do, but I also think they may have some sort of short circuiting system for the initial JP filing. I'm not an expert on Houston, but that's limited to very few jurisdictions. Generally speaking, if you get your case dismissed, the lawyer that helped you with the case being dismissed is the one to ask about whether or not you need an expunction, but generally the answer is yes.
Well, I have heard of this program because I'm still buddies with the first assistant there, the blue
Yes.
So I'm calling about it, and I wanted to punch him in the face. I actually set up a meeting with him and the first assistant with the DA's office to talk about stuff like that and to move El Paso in the right direction. But I think that the case or the question on the chat, I think it refers to maybe completing a deferred adjudication.
Oh.
So if you do get arrested, you go to jail, you get processed, you get what's called the cause number in a case, and that gets dismissed, or you get a not guilty trial, meaning the prosecutor said we moved to dismiss this case for whatever reason. Then you can get it expunged, which means that law enforcement, judges, DAs, it's like the arrest never happened, right? No one gets to see it. However, if someone here is talking about completing a deferred adjudication, that's what we refer to as a legal fiction, in that you can't get it expunged. You can get, in Texas, you can get an order of non-disclosure, which only keeps that from private entities seeing that. So you can't get it expunged still. You can get, jobs, places like that from seeing it, but cops, DA's offices are always going to be able to see that you got that PON, that marijuana conviction, or that marijuana case, and completed deferred.
All right.
So there's another El Paso question on here, actually, about there's two children patients that are in the Texas Compassionate Use Program, but they're not allowed to bring their medication with them to school because it is a drug-free zone. I know that there has been a fight about this in Colorado to make sure that kids could have their medicine on hand. So is there anything like in Texas that parents could try to do to advocate for their children to be able to have that medicine on campus with them that you guys know of?
At this point, I don't know what the remedy there is. I suppose somebody should, go to court in a civil case to try to get some sort of an enforcement action to allow that, because that's non-criminal and it's well outside my area of expertise. It seems like it should be challengeable, but I don't know. There's my weasel answer. You guys have anything to add?
Well, it's in El Paso, so if it has to be a legislative fix, I mean, I can think of quite a few legislators out there who support cannabis law reform that I would encourage the participant to reach out to and talk to about this. And it might even be something worthy of bringing up to the actual author of the bill, Representative Click. This session, there was a child protection bill that passed that was actually authored by James Franks that included protections for children that were enrolled in the Texas Compassionate Use Program, but including, having their medicine at school with them was not one of those protections. So I just want to put that out there. All right, so we've just got 2 more questions up here, and then we'll finish up. I think we've gotten all the ones off of the Facebook stream too. So we have an anonymous one. I work in the medical field as a physical therapist assistant. I have PTSD from being assaulted during a robbery. My question is, should I let a hiring organization know I use CBD or very low-level THC to treat the PTSD, or announce that I have a medical card before I am drug tested? I could lose my license to practice for having a failed drug test.
So I have a couple of friends that practice essentially medical license defense. It is extremely technical. And I think this person needs to consult somebody that is an expert in that field. And that's for 2 reasons. Not only so you can get the real answer to that question, it's a good question from a lawyer that knows the real answer, but the problem is this. Sometimes on those types of forms, and I don't know on this specific one, but I get questions all the time from former clients about dismissed cases. Hey, Jamie, you handled my case. You got it dismissed. I guess I didn't, you told me I should expunge it, but I totally ignored that. Now it's 5 or 10 years later. And here's the question that I have to ask that I have to answer on this job application or this license renewal. Well, a lot of times the person in a licensing field might answer the question truthfully, such as if they were placed on deferred adjudication probation for an offense and they said that they weren't convicted of it. But the person who's grading that may not know what the law is, and they might just get some sort of record that they realize, okay, well, this person pled guilty and was placed on probation, so I believe they lied to me in the application. And the reason I bring that up is, the reason I think some level of legal advice for a question of that detail is important is you don't know what they think the questions are that they're asking. They don't know. They don't know how to interpret the results. And most of the time, if you have a legitimate issue or legitimate need to use a medication, you would think that wouldn't be an issue. However, if they think that you've lied to them, even if you haven't, they can punish you for that. And then you really have to go back and hire a lawyer and prove to them that you were correct all the time. So that's a really kind of fine-edged question. I don't know what kind of medical marijuana card you have. If it's Texas, depends on what you mean by a medical marijuana card, I suppose.
I would think to have a protection, you would have to be enrolled in the Teacup program.
I assume that's kind of what it's referring to.
Yeah, and PTSD is not included yet, so maybe they're under another qualifying condition, but starting on September 1st, PTSD will be included. And after we talk about this last question, I am going to kind of segue a little bit into talking about the patient tutorial. So the last question here is, when should we expect decriminalization and or legalization in Texas? So quick, too long didn't read of how it works here in Texas is we have a legislative session every 2 years. So we have a 2-year cycle. The legislative session just ended, and we were able to get patient protections and expanded medical access There also, of note, was a concentrate decriminalization bill that had DA support, and it was a rural DA, y'all. And that almost passed out of the House, but in an attempt to ban Delta 8, Lieutenant Dan Patrick killed that bill. So that also gives you guys a little bit of the feel of up at the Capitol, how things are going. So I would say during this interim, what is going to affect next session is what happens mostly at the federal level. We have a lot of work to do here, what you guys are doing at the local level, of course, to create support from below, but also if we look back historically at the hemp program, you know, hemp was decriminalized at the federal level, and in Texas, there's a mechanism with which we have to match our CSA with that. And so by March, it was essentially decriminalized, but there was no regulation in place. So either Texas had to go with what USDA wanted to do, or we could come up with our own thing. So Texas is like, hold up, we'll do our own thing. And they put something together. So I think it could potentially be something similar with that. If Biden keeps his promise to decriminalize or deschedule marijuana at the federal level, then that will put an onus to put statutes and regulations in place for a market here in Texas. So that is going to be a huge thing. It's also going to be, you know, primaries happen in March of 2022. Texas NORML will be putting out our voters guide about that. But in Texas, there's a lot of gerrymandering. So it's really the primary races where you can make the most impact, and making sure that the candidate that represents this winning party of your district is as cannabis friendly as possible. So that being said, the next opportunity to change the law is going to be in 2023, unfortunately. The good news is that there's a lot of these deprioritization programs, and they are spreading a little bit to the rural areas, but it is a patchwork of policies. So I just would remind everyone to be very careful, and go back and watch some of our old Ask the Lawyers about, you know, what do you do during a traffic stop? You know, don't eat your weed. There's a song about it. That becomes a felony. So things like that. I know you guys probably don't want to know all these things, but we would really like for y'all to not be in jail or arrested. So anything that y'all would like to add about your opinions on decrim and legalization in the interim?
I want to tell everyone, go to jury duty. On behalf of all defense lawyers, if you're watching this, show up, because when a DA can't even make a panel because the people are going, we don't want you prosecuting weed cases, that can change something where you live. I mean, we had a jury, and a lot of people gave pretty negative feedback that the DA was trying to prosecute a cannabis case. And so if you don't show up, I mean, you don't matter, you can't help anyone. But if you do show up, you might be able to help somebody and really save them from a terrible fate. So just go to jury duty, please.
I have jury duty on Friday.
I want to echo that, because if you don't want to be on jury duty, imagine the person that does, right? That's really wanting to get out there, making sure someone doesn't get away with anything. And specifically here, Ms. Diego, I'm putting this in the chat. You can try to. I'm a founding member of this group that started this last year called the El Paso Alliance for Just Schools. I'm not that familiar with the issues that you're talking about here. However, we are right now exploring, you know, issues in the public schools here in El Paso with the presence of the police department and stuff like that. So if you contact us on Facebook, we may be able to explore that issue. And I might personally be able to put you into contact with some civil rights attorneys here in El Paso that may be interested in taking up that cause.
Awesome. Thank you for that. And I totally want to be kept in the loop about what happens. I'm nosy and I want to know. All right. Well, thank you, gentlemen. I'm going to real quick talk about 2 upcoming events that we have going on, and I'm going to share my screen to do so. The first one is going to be this pretty graphic. We are changing up the way that we do our meetings. We've found that these monthly meetings being virtual is really great. We can have people from across the state, as we have today, and we can have you know, kind of more in-depth conversations, but we really missed being with people in person. And so we decided we'd do quarterly summer socials. So the next one will be on Wednesday, the 18th. We're going to be back at the Flamingo Cantina. We're happy to be back there, and we're going to have music from the Mau Mau Chaplains. And it's really great because this company called Space City Wellness has this CBG ice cream, and they are donating their first 50 scoops to the first 50 people, and then they'll have a discounted rate for everybody else. So if you are up for it, we would really love to have you guys join us. And then the other one that we were talking about is this one having to do, now is that like really tiny? I feel like it's tiny. Oh, well, this is what we have for now. So the Texas Compassionate Use Program, these are some of the qualifying conditions here. And of course, there's a few dozen incurable neurodegenerative disorders that are not on this list. But starting on September 1st, cancer, all forms of cancer, and PTSD have been added to the program, and they will also change their formulations from 0.5% to 1% THC. Now, I would like to make a clarification. That does not affect the amount of THC that you will be prescribed. You will still be prescribed whatever your doctor thinks your THC level should be. It just means that you will be taking less of the carrier oil or whatever the carrier product. Imagine that you have a slice of a cookie. They're saying that 1% of it can be THC now instead of 0.5%. Because you know what I like? Taking a medicine where 99% of it is something I don't need to ingest. That's what I like. But the good news is that they are coming out with a whole line of gummies that have less of the side effects that the oils and the tinctures have. So we will talk about how do you get enrolled in the program, what does the appointment look like, how do you fulfill your prescription, and then where do you get your medicines. We'll also hopefully be able to talk a little bit about potential contraindications or interactions with medications that you take. So other than that, we will be back in September, first Wednesday of September for our next monthly meeting. That's all I got. What do you guys have? Any final words?
Just thank you to my guests for coming and helping tonight. It was super fun, and thank you everybody for joining. And that's it.
Thanks.
Thank
Appreciate
you,
it.
Robert and Renee. Appreciate it. Thanks, Jamie. Bye, everybody.